Okay, this one's tense from the start. We're in a bond revocation hearing for Rebecca Miles. Translation? The court's deciding whether she gets to stay free or head back to jail. Let's see how the prosecution and defense battle it out over a single piece of paper that could change everything.
Right purpose, Your Honor.
I object to admission of that document. Violates confrontation.
Your Honor, I believe literally out of this county with Judge Locker Mash, that went up to the Court of Criminal Appeals. The Court of Criminal Appeals ruled that that was sufficient on its own. I'm trying to get the exact case. I could find that out, but that literally came out of this very circuit court county, Your Honor.
I don't.
See that? The prosecutor just entered a certified copy of her new arrest. As evidence, no witness, no testimony. Sounds weak, right? But under Tennessee law, even an arrest, not a conviction, can justify revoking bond. It's one of those gray areas where innocent until proven guilty starts to blur.
I don't have the case in front of me, but I'm understanding that is the rule that has been adopted by our Court of Criminal Appeals. So as a result of that, I will have this marked. It is a certified copy. I'll have it marked as Exhibit 1, and that is the state's proof under the statute, which allows the state to seek the revocation of bond based on a subsequent arrest for a person who's on bond. Is that correct? All right. Mr. Flanagan, do you wish to offer any proof?
Maybe. This motion to revoke bond, and that's the DA's office here always styles it that way, but they leave off the other options. It's a motion to revoke, alter, or amend. So this thing that's been handed to you is now an exhibit is...
Boom. The judge just agreed the state met its burden. That's a turning point. Rebecca's fate now rests on the court's discretion. In other words, the judge can decide to revoke her bond, raise it, or modify it. Absolute power right here at the bench.
May be sufficient to show that the bond condition has been violated, but the court has discretion on what to do with it. And so I think that's where we are. So if the court is now ruling that they have sustained that the bond condition has been revoked, then we'll go to what needs to be done.
Well, based on that case that Mr. Stevens has referenced, is in my own understanding of the current state of the law, a certified copy of a subsequent arrest record is admissible, and under the statute that the state is proceeding under, they have the right. It doesn't require conviction. It says anyone who is on bond or in bail and is arrested on a subsequent offense, that the court has the option of revoking their bond. So
Yeah.
I think that the state has met its burden to show that there is a basis for the court to consider any revocation of the bond, or as you state, the statute allows for modification of the bond. So the state, in my opinion, has met its burden to show that there is a basis for review of the defendant's bond, either a revocation or a modification. So if you wish to offer any proof about that, then I'll be glad to hear it. So.
Well, I guess my position is now, has the state put on enough just with that to justify a revocation of the bond? I mean, that's all the proof you have before Your Honor. So you got three choices. You can raise the bond. You can put different restrictions on her. So my position is they have not met the burden to show that one of these other options is not appropriate. So I'm asking the court, as a matter of law, to alter or amend the bond.
So you're basically asking me to alter or amend it, okay?
Yes, because
I understand what you're asking.
Yeah, they
So-
put that.
Let me hear what the state's argument is. If we're not going to have any proof, then I'll let you both argue what you think the appropriate disposition is.
Well, let's do it this way. I can have just a moment.
Okay.
Would you state your name for the record and please spell it?
Shonda Vargas. It's SHONDA VARGAS.
Okay. Ms. Vargas, where are you employed?
Serenity Ranch Recovery in Mammoth Cave, Kentucky.
Serenity Ranch?
Yes, sir.
Okay. And has Ms. Miles already been admitted there?
Yes, sir.
And
Turn your microphone on.
a new charge you've already carried the burden on that, General. New charge has occurred. We're talking about disposition.
So just to clarify, is Mr. Flanagan seceded the point that his client violated the conditions of bond, and this is for the purposes of what to happen? Because at this point, I think it's irrelevant to whether or not she picked up new charges while on bond.
The court's already ruled in your favor on that, General.
I have ruled, as a matter of a finding that I've made, that the introduction of this certified copy is sufficient to meet the burden that the state has to show that there is a basis for the court to consider whether or not to revoke the bond. So I've made that finding. Mr. Flanagan is now wanting to produce proof that would offer alternatives to the actual revocation by offering, I'm assuming, some testimony that would indicate there is a basis for a modification of the bond, which is one of the options that the court has in this particular case. So as far as relevance, it is relevant, and I don't know, I haven't heard everything, but it's relevant as to what the defendant's present situation is and what, if any.
Now watch the defense pivot. They stop arguing the arrest itself and start pitching redemption. Rehab over jail. They're reframing Rebecca not as a danger, but as someone finally taking responsibility. It's a tactical move appeal to the judge's sense of humanity instead of the letter of the law.
Modification should be made versus revocation. So I'm going to, unless you have some other basis for the objection, I'm going to allow it to proceed.
Yes, sir.
Tell the court about the program.
It's a 28-day detox and residential program where we help individuals overcome substance abuse disorders, and we also deal with mental health, so we are dual diagnosis. After the 28 days, we do help clients go to the next step, which would be a partial hospitalization program, a PHP. We do help them get that set up if that is something that they are interested in to continue their recovery, to help them in that sort. We have therapy, we offer therapy, case management, and things of that sort, also group therapy. It's just kind of to get them to go on to the next step in their recovery.
Okay, so she's been admitted.
Yes.
Been there a couple of days, right?
I want to say she's been there about a week, but I'm not
Okay,
positive
about a
about
week.
that. Yeah.
And she'll be there for at least 28 days?
Yes, sir.
Could it be longer?
Not in our program, but we can set it up so she can go straight from our program to another program that would be 30 to 90 days.
Okay. And at my request, you brought her here today because you knew she had to be in court.
Yes, sir.
If she were to leave the program, would you notify me and/or the district attorney and the court that she left the program?
Yes, sir.
That's all I have for you.
Stevens, do you have any questions? You don't get off that easy. The state has the right to ask you questions.
This is kind of nerve-wracking.
Good afternoon, or good morning, ma'am.
Yes.
Just a few questions for you. So when you go through that, are you aware of any of her prior charges as part of this when she goes into a program?
Yes, sir.
Okay. So you're aware of about 20 prior domestic charges?
I mean, I'm not personally, because I don't do the admission part. I work with the clients on a daily basis. That's all. That's my job.
Okay. What about 20 prior charges for violating conditions of bond?
Again, that's not my job. I don't do the admission part. I just help the clients when they come in.
What about 5 times failing to appear?
Again, that's not my job. I don't work with the admissions. I don't know what we know about her prior charges, but I do know that she had charges because we brought her to court today.
Are you aware she's a convicted felon for aggravated assault?
I mean, most people there are.
Okay.
Yeah.
That's all that I have. Thank you.
Nothing further this witness.
Thank you,
If the
ma'am. You
court
may step
doesn't have
down.
any questions.
Any other witnesses?
No, Judge.
State wish to offer any proof?
Her husband, Mr. Robert.
All right.
Ouch! The prosecutor just dropped a bombshell. 20 prior domestic charges. 5 failures to appear and a felony record. That's a credibility killer. No matter how sincere the rehab pitch sounds, the state's building the case that Rebecca's out of second chances. The courtroom tension? Off the charts.
Mr. Robert Miles.
It has to do with the disposition. And Judge, before we get started, because I don't represent him, he is the victim in this assault. I think the state is going to ask him questions about what happened. And I explained to him that if his testimony here today is different than what he told the officers, he could be charged with filing a law. I don't represent him. The court wants to talk. And I told him I don't want to put him. That's why I didn't talk, because I didn't want to put him.
Mr. Miles, well, first of all, Mr. Stevens, are you intending to ask him about the factual basis of it?
I am, Your Honor.
Mr. Miles, you are the alleged victim in this case that's being used by the state as a grounds for the revocation of Ms. Miles's bond. In that, the officer who made the arrest is stating that you gave him information that, and I'll read this to you. It says, I made contact with Joseph Miles in front of the residence while Sergeant Mutter spoke to Rebecca Miles on the front porch of the residence. Joseph explained that him and Rebecca were eating Chinese food in Bellevue. Joseph stated him and Rebecca got into a verbal altercation at the restaurant. During the verbal altercation, Rebecca stabbed Joseph in the right hand with a fork. And then it also says that once you returned to your residence, Joseph stated that when he turned on Trace Creek Road, Joseph stated Rebecca started striking him in the face, chest, and groin. And I observed noticed a bruise under Joseph's right eye. So what Mr. Flanagan is wanting you to understand is that if you gave information to a police officer that they used in reliance on obtaining a warrant against your wife for domestic assault, and you are asked those questions today under oath, and you answer differently than that, there is a possibility that you could be subjected to criminal prosecution yourself, because there's a statute that makes it a crime to give false information to a police officer. Sometimes people get mad and they say things to an officer, they make a false report. And the reason they make a false report is because they're angry, upset, or whatever, and it's not true. But sometimes people decide they don't want to really, have to see what happens, so they want to change their story. But you have to understand that when you testify today under oath, then those questions, those answers could be used as evidence against you if you change your version of what happened. You also, as a citizen of this country, have a right under the Fifth Amendment of the Constitution to decline to answer any question that might tend to put you in danger of criminal prosecution. You understand that? You understand everything I've asked, I've advised you of?
I can decline the question.
You can decline to answer a question if you think your answer could potentially put you at peril for criminal prosecution. You can decline to answer because your answer might tend to incriminate you in criminal prosecution. Do you understand that? All right. You understand everything I've explained to you?
Yes.
All right. Mr. Stevens, you may ask.
Sir, please state your name.
Joseph Miles.
And Mr. Miles, how do you spell that for the record?
Joseph Miles.
Mr. Miles, who is your spouse?
Rebecca Miles.
And how long have you been married?
It's about 3 years now.
3 years. What was her maiden name?
Rebecca Fain. Fain.
How do you spell that, sir?